So friends, now that we know that one of Donald Trump's lawyers made an audio recording all about his representation of Donald Trump, I have received one question over and over and over again. Is that normal? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as something of a follow-up to yesterday's video in which we talked about the revelation that one of Donald Trump's lawyers, Evan Corcoran, made a lengthy audio recording about his representation of Donald Trump, including questions that Donald Trump asked him, legal advice that Evan Corcoran gave Donald Trump, and other matters. Well, since that video yesterday, there has been one question that I have been asked over and over again. In fact, earlier today, when I was on air with Jen Psaki, Jen asked me precisely this question. Is that normal? Well, the answer is yes. And let's talk in a minute about why it's normal, but first let's go back and look at just a little bit of the recent reporting from the New York Times. Headline, Trump's lawyer's notes could be a key in the classified documents inquiry. And that article begins, turning on his iPhone one day last year, the lawyer, M. Evan Corcoran, recorded his reflections about a high-profile new job, representing former President Donald Trump in an investigation into his handling of classified documents. In complete sentences and a narrative tone that sounded as if it had been ripped from a novel, Mr. Corcoran recounted in detail a nearly month-long period of the document's investigation, according to two people familiar with the matter. Mr. Corcoran's narration of his recollections covered his initial meeting with Mr. Trump in May last year to discuss a subpoena from the Justice Department seeking the return of all classified materials in the former president's possession. It also encompassed a search that Mr. Corcoran undertook last June in response to the subpoena for any relevant records being kept at Mar-a-Lago, Mr. Trump's private club and residence in Florida. He carried out the search in preparation for a visit by prosecutors who were on their way to enforce the subpoena and collect any sensitive material found remaining there at Mar-a-Lago. So friends, the question is why? Why would Evan Corcoran make this lengthy audio recording about his representation of Donald Trump, a sort of memo to self, a memo to the file? To protect himself. You know the saying, no good deed goes unpunished? Well, friends, let me tell you, when you're a criminal defense attorney representing a client in a criminal investigation or in a prosecution, here is what will often happen. That attorney may aggressively and professionally and zealously represent the client. In fact, at trial, that defense attorney might fight tooth and nail, honorably, fairly, but zealously, to try to win an acquittal of the client, to try to get a not guilty verdict. But often the evidence is strong and the client gets convicted anyway. You know what the first thing is that a client will often do after he or she is convicted? They will claim it's the lawyer's fault that they lost the trial. They will file what's called an ineffective assistance of counsel claim. Wasn't my fault because I committed the crime and the evidence was compelling. It was my attorney's fault because he or she didn't do a good job. In fact, he or she didn't do what I told them to do. Now can you see why it's so important for a defense attorney to have documented everything they did in furtherance of their representation of the client? All of the legal advice they gave based on the information the client presented to them. It is to protect themselves against what is often the inevitable claim of ineffective assistance of counsel. My attorney didn't do the job he should have done. Let's use an example. Let's say that Donald Trump, after he is indicted, and indictments are coming, after he's indicted for the classified documents, crimes he committed. What if he said, whoa, 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 my attorney told me I did not have to return the documents. In fact, when we got that subpoena from the grand jury, from Jack Smith and his prosecution team, I asked my lawyer and he said, no, these fall under the Presidential Records Act, and anyway, you declassified them and you don't have to give them back in order to comply with the subpoena. Can't you see Donald Trump saying something like this, throwing his lawyer under the bus, looking for any excuse he can come up with to, try to get out from under criminal responsibility? Well, let's look at a short passage from the New York Times article against that backdrop. Quote, in an early scene, and by scene that is part of the audio recording that Evan Corcoran made, his memo to self, in an early scene in his account, Mr. Corcoran describes meeting Mr. Trump at Mar-a-Lago last spring to help him handle a subpoena that had just been issued by a federal grand jury in Washington, seeking the return of all classified material in the possession of his presidential office. After pleasantries, according to a description of the recorded notes, Mr. Trump asked Mr. Corcoran if he had to comply with the subpoena. Mr. Corcoran told him that he did. So that, friends, is why defense attorneys make memos to self, memos to file. So when and if the client lies about some aspect of the representation, or when Donald Trump claims Evan Corcoran did or did not give him certain legal advice, Evan Corcoran can pull out that contemporaneous memo, that account of precisely what Donald Trump told him and what advice he gave to Donald Trump. Now, ordinarily, folks, prosecutors don't get to see these memos. We don't come into possession of them because they are generally covered by attorney-client privilege, unless the client is using the attorney in furtherance of a crime. And that's what Judge Howell in federal court in Washington, D.C. ruled. Donald Trump was trying to use Evan Corcoran in furtherance of a crime, and therefore the attorney-client privilege evaporates. It yields. It is extinguished by what's called the crime fraud exception. That's why Jack Smith and his team got to see and hear what's in Evan Corcoran's memos. Now, there's one other circumstance where prosecutors can take advantage of these memos. We can get a hold of them. We can see them. It's when the client makes a claim against the lawyer that the lawyer was ineffective. The lawyer didn't do the job he or she was supposed to do. I told them to, for example, go out and interview these witnesses, and the lawyer didn't do it. And I am now making a formal claim against my lawyer that I got ineffective assistance of counsel. And the Constitution provides everybody a right to counsel under the Sixth Amendment, but not just any old counsel, a right to effective counsel. So when a client lodges a complaint against an attorney and says, my conviction should be thrown out because my attorney didn't give me effective representation, well then any of these memos that the attorney produced to document the nature of the relationship with the client and the legal advice the attorney provided can be given to the prosecutors. Why? Because we then have to go into court and argue against the defendant's ineffective assistance claim to show that he was properly convicted and that the conviction should stand. It should not be thrown out. He should not be granted a new trial. And under those circumstances, friends, think about it, the interests of the prosecution in protecting and defending the conviction and the interest of the defense attorney defending his or her reputation against these allegations by the client that the attorney was ineffective, constitutionally ineffective. Those interests align. And that's why we get those memos, because we need to go in and argue that a motion for a new trial, because the defendant was claiming the attorney was ineffective, should be denied. That's the other time we get a hold of those memos to file that are generated by defense attorneys. And here's the thing, friends. When we're in a position where we have to defend the defense attorney against a claim by the client of ineffective assistance after the client was convicted, defending defense attorneys against false claims of misconduct, like justice, matters. Friends, hold on tight. Looks like the ride is about to get a little bit wilder, because with the recent reporting and the grand jury returning after basically a month of downtime, the grand jury in the classified documents crimes investigation returning on Monday, it looks like Jack Smith may be at the investigative endgame, and it may very well be that we see our first federal indictment of Donald Trump very soon. And we will be here bringing it all to you all day, every day. So friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again soon.